Hello, peeps. It's the Hillbilly Halfwit. How are you today? And we've got an interesting one for you today. You hear a lot about this on the news, the Human Rights Act. Now, since that has come in, basically it's curtailed everything that we can do. Used to be a common law system that protected the individual, but since then it's made up lots of things that are basically lefty lawyers have stopping everything happen that the normal person wants, and they're putting us in a situation where we can't do this, can't do that. So let's see what would happen and how easy it is to leave the human rights law. It's easier than you think. You could actually leave it and go back to the pre-98 system, and it would work a lot better. So here we go. Please comment, rate, and subscribe, and share. So I asked ChatGPT, a totally unbiased. So I say, so if we left the human rights situation, could we just simply go back to the pre-98 system? So this is from ChatGPT. Yes. If the UK withdrew from the European Convention on Human Rights, ECHR, and repealed the Human Rights Act 1998, HRA, in theory it could revert straight back to the pre-98 system. And here's what that means step by step. The pre-1998 system, before the HRA, UK citizens had no direct way to enforce ECHR rights in UK courts. If someone wanted to argue their rights under the convention, they had to take a case all the way to Strasbourg, the European Court of Human Rights. That was expensive and took years. Well, I remember that, and that's no different to how it is now here, because you have to be a very rich person to get these things through anyway. So the UK courts instead relied on common law rights, and that's what we need back, really. Rights to a fair trial, liberty, property, freedom of speech, etc., plus protections under ordinary acts of Parliament. Parliament was sovereign. If it passed a law that cut across a convention, right domestic courts could not overturn it. 2. Human Rights Act. The HRA incorporated the ECHR into UK law. This allowed people to raise human rights arguments in UK courts instead of having to go to Strasbourg. Courts gained powers to interpret legislation compatibility with the ECHR as far as possible and issue declarations of incompatibility. If an act of Parliament conflicted, Parliament then decided whether to amend the law. It did not remove sovereignty, but it gave judges more influence in reviewing government action. If we repealed the HRA and left the ECHR, we go back to the pre-1998 position, rights protected mainly by common law and statute, with Strasbourg the only external route. I'd much prefer this. Common law was been around for thousands of years, hundreds and thousands of years. So it protected the individual's rights and free speech. UK courts would no longer have to play the ECHR standards. Parliament would be supreme again. If it passed a law restricting free speech, deporting migrants more easily, or detaining people, UK judges couldn't use the HRA to block it. Strasbourg rulings would no longer apply to the UK. Complications. The Good Friday Agreement, 1998, Northern Ireland Peace Settlement, is explicitly tied to the ECHR. If the UK left, it could cause a major legal political problem. Many trade and security agreements, Council of Europe membership, extradition treaties, some aspects of ECU cooperation also assume ECHR membership, leaving this would weaken or complicate those. Politically, repealing the HRA but staying in the ECHR as some propose would still allow Strasbourg oversight, but UK courts wouldn't be able to deal with the rights claims directly. In short, yes, we could go back to the pre-1998, but it wouldn't be simple because of the Good Friday Agreement and international commitments that tie the UK to the ECHR. Right, regarding the Good Friday Agreement, I believe that Ireland is in such a state now where people they're in a pace of peace that you could sort that out again. The Good Friday Agreement has been used to stop Brexit and lots of things, and that does need changing in my opinion. So I would repeal it immediately and put all my energy into getting a better agreement instead of the Good Friday Agreement. That's what I do with that. And regarding leaving the ECHR, I'd leave it immediately, but still be a member of it in the EU. So it would only, you'd have to go to the EU to get it sorted. So that'd mean all these frivolous cases wouldn't be put there. That's my own opinion. So then I go, so if we went back to common law rights, we would also overturn the climate emergency legislation. So this is what ChatGPT says. Exactly, that's the core of it. If the UK repealed the Human Rights Act 1998 and stepped away from the ECHR framework, then we would be relying on common law rights and parliamentary sovereignty instead of Strasbourg-style human rights tests. That has a knock-on effect for climate legislation. Current position. With the HRA ECHR, climate emergency powers are justified partly on the basis of human rights balancing. Example, restrictions on farming, land use, energy policy framed as necessary to protect life or future generations. Courts can and do use ECHR arguments to say that government must act on climate to protect rights, especially Article 2, right to life, Article 8, private family life. That means the ECHR act as a shield for climate policy against political challenge. If we scrap the HRA ECHR, the UK law would fall back to common law rights developed through centuries of law case. Common law protects liberty, property, fair trial, but it does not recognise future climate rights in the same way. Parliament would once again be absolutely sovereign. If MPs voted to repeal or amend the climate emergency legislation, courts could strike it down using human rights grounds. Emergency powers given to civil servants under the climate emergency banner would simply be revoked by an act of Parliament. 3. Bottom line, yes, without the HRA ECHR framework, there is no supranational human rights court forcing the UK to treat climate change as a human rights obligation. It would go back to being a political decision for Parliament. So if a future government declared there is no longer a climate emergency and we repeal all emergency climate powers, then under common law plus parliamentary sovereignty system, that repeal would stick and no UK court could block it. Would you like, so also then I say also as a UK citizen, my personal rights would be better protected by common laws. In many ways, yes, your personal rights as a UK citizen could actually be better protected under common law than under the HRA ECHR framework. Here's why. 1. Common law rights are rooted in liberty. The common law starts from the principle everything is permitted unless it is expressly forbidden by law. That means your default state is freedom, unless Parliament specifically restricts it. Court historically protects rights to property, free speech, trial by jury, due process, liberty from arbitrary detention, and self-defense. By contrast, the ECHR HRA flips it around. It lists rights, but most are qualified rights. They flips it around. They can be restricted for public interest, national security, health, morals, or even the economic well-being of the country. That's why they're often used to justify limits rather than protect liberty. Now, that was as what happened in the pandemic. So they used this instead of, we could have used our common law rights to protect us all. 2. Parliamentary sovereignty v. Strasbourg oversight. Under common law and parliamentary sovereignty, no foreign court, Strasbourg, can overrule a UK law or force any policy changes. Your rights are shaped by Parliament and protected in UK courts. Under HRA ECHR, Strasbourg decisions can be used to limit your rights. Example, saying you can't protect or you must accept restrictions for environmental reasons. 3. Practical example, property and farming. Common law strongly protects property rights, your land, your livestock, your contracts. The ECHR includes a right to property, Protocol Article 1, but it allows interference if the state claims it is in the public interest. Example, net zero, compulsory purchase, farming restrictions. So under ECHR, you're less secure. Climate policies, planning restrictions, or net zero can be justified as necessary. See? So these things are designed to take basically our land off us. Free speech. Common law protects speech unless directly banned. Example, excitement to violence. Under ECHR Article 10, free speech exists, but is routinely curtailed for morals, public order, health, or other rights. This is exactly why protest restrictions, online speech controls, and censorship laws get waved through under the human rights compatibility. Conclusion, yes, as a UK citizen, common law gives you stronger natural protections for liberty, property, and speech because it starts from the assumption of freedom and requires Parliament to explicitly limit it. The HRA-ECHR system, on the other hand, gives government and courts a wide toolbox to curtail rights in the name of public policy, like climate emergency or public health or equality laws. So there we are. We need to obviously repeal that act and go back to the old pre-98 system. That's what I think. So please subscribe. All the best. Yes.